Okay, well, I'd just like to start by opening the webinar. Thank you all for joining us. I appreciate you all taking time out of your day to listen to us. COVID has presented a number of challenges for all of us over this last year or so, not least connecting with our peers and with our clients. Webinars have provided us with a way to reach out to all of you and in particular reach a lot more of you. So we're very grateful to have you here today. This webinar in particular is for anyone who's concerned about the intergenerational transfer of wealth, either personally or professionally, what we can do to protect estates and our clients from unnecessary fights, and also protect individuals from abuse, particularly financial abuse during their lifetime. We're finding more and more that clients are very aware of the risks of challenges to the estate, the costs that this incurs, and also the distress for all the family members and all of the parties involved. In addition to this, front of mind at the moment for a lot of people, particularly after media attention, the Law Reform Commission report, and also government body attention, is the topic of elder abuse. So Ilana is going to be covering that today, and we look forward to starting the presentation. So I'll just move on to some housekeeping now. So all attendees will be on mute and their cameras will be turned off for the entire webinar. We do have a business development tech support team live to assist us with any technical issues. Please could you use the chat function for any comments you have or any on any technical issues. The question and answer function is for any specific questions related to the webinar content, and questions we'll be addressing at the end of the webinar. There will be a survey link sent at the end of the webinar, and we really do value your feedback. Presentation slides will also be sent to all the attendees. Finally, we also have a QR code which links to our feedback survey, so you can provide instant feedback at the end. Just on the topic of disclaimer and housekeeping, the information contained in this presentation is intended to be general commentary only, shouldn't be regarded as legal advice. We are happy to provide you with specific legal advice if required, so just please contact us. I'd like to now introduce you to Ilana Kacev, who's Special Counsel in our Melbourne office. Ilana is a Law Institute Wills and Estates accredited specialist. She has well-rounded experience in both estate planning and estate disputes. This gives Ilana the insight and the expertise to provide clients with a holistic and strategic advice and approach to their affairs. She regularly represents her clients in the Supreme and County Courts, as well as the Victorian Civil and Administrative Tribunal, as well as mediations. So I'd like to hand over now to Ilana.
Thank you, Claire, for that introduction, and thank you everyone for attending today. We've broken up the presentation into two main parts, with Walter speaking about family provision claims, which are probably the more commonly known claims. And I'll be speaking about other types of estate disputes, which are will validity claims, informal wills, and abuse of powers of attorney or elder abuse, as Claire mentioned. So I'll start with the first one, which is will validity claims. And these types of claims are brought before probate is granted and relate to whether a will can be set aside in its totality because it was not validly made, as opposed to a family provision claim, which is based on whether adequate provision has been left for the beneficiaries. Probate's the process whereby the court formally approves the final will as a valid last will, therefore granting the executor with the authority to administer the estate based on the will admitted to probate. When someone dies without a will, a similar application is made, but it's called letters of administration, and the court will grant authority to the closest next of kin to administer the estate, and for the estate to be distributed based on the rules of intestacy. Sometimes the standing of one person making this application can be questioned too. For example, a person might claim that they were the de facto partner of the deceased and are therefore the closest next of kin. But the broader family will challenge this and say that the deceased and that person were not in a relationship at the time of death. The effect of these types of claims is that the estate could be distributed on a previous will or on intestacy, meaning the estate is distributed pursuant to a statutory scheme when someone dies without a will. And that might be more favourable to the claimant. In terms of the grounds for setting aside a will because of validity issues, there are four main types of grounds. The first is lack of testamentary capacity, which goes beyond the standard test of legal capacity, but actually has a four-stage approach to it. And a lawyer drafting a will needs to make sure that they're satisfied of that test before drafting a will. The capacity is assessed just before and at the time of making the will. There was a case called Banks and Goodfellow which set out that four-stage approach, which is the will maker must understand the nature and effect of making a will. So they have to realise that the document they're signing is disposing of assets after their death. They must also know the nature and extent of the assets held. So they need to be able to state what their assets are and what their approximate values are. They must comprehend and appreciate the claims to which they ought to give effect. So if a lawyer gives them advice to the effect that if they've excluded someone and that person is eligible to make a claim, they have to be able to weigh up the risks of such a claim and appreciate that it's a risk for them. And they must not be affected by a mental disorder that influences the disposal of their estate. So certain cognitive conditions such as Alzheimer's, dementia, mental health conditions, and also certain medications such as very strong pain relief are all types of things that could potentially impact on one's testamentary capacity. The second ground is lack of knowledge and approval. And it's usually connected and intertwined with lack of testamentary capacity, because if someone's not capable of understanding, then they may not have known or approved of the contents of the will. But sometimes there's also a physical condition that can affect their ability to understand. So, for example, it could be that they're blind and the will was not read out to them by one of the witnesses or an independent person, and so they didn't know what they were signing. The third ground is undue influence, which is where the will maker's free will was overborne so that the directions under the will were not freely made by them. This is often a really tricky one to prove because the person who's actually capable of providing the evidence on this point is the deceased, and they're not around to give evidence. And then the person who the allegation of undue influence is being made against will often defend their position because they usually stand to gain from this final will. The other ground is suspicious circumstances. So that is a process of viewing the circumstances of the making of the will, where it was made, when it was made, was anyone present at the time, who might have brought the will maker to the appointment, and really viewing everything all together. I recently worked on a matter which we were successful in, where our client was the son of the deceased, and the deceased made 3 wills in very close succession in 2017. It was done in, one was in April, one in May, and one in June of that year. And our client was excluded from all of those 3 wills. And the deceased was 89 years old at the time. He had just entered into aged care in about April when the first will was made. His wife was in palliative care, and in between the second last will and the final will, his wife died. And he only made the last will about 5 days after his wife died. The wills were updated so that he essentially left everything to his former business partner, who he had had a falling out with. And he excluded our client on the basis of that our client had said he didn't want to be a beneficiary of his estate, which was quite a nonsensical excuse because it didn't really represent what the will maker wanted. It represented what someone had potentially told him. And the deceased was also declining quite badly at that time. He had Alzheimer's for a number of years. So we were able to argue that the deceased lacked capacity, he had been influenced, he didn't know or approve the contents of the will, and that viewing the story leading up to the making of the wills, it was all quite suspicious. The types of people who can make these claims are anyone who can show that their rights might be affected by the outcome of the proceeding. So that could include a beneficiary or an executor under a previous will, or a person entitled under intestacy if the final will is set aside. For example, a final will might exclude children and leave everything to a friend. There could either be previous wills where everything was left to all of the children, or maybe there are no previous wills, but the children would be the surviving next of kin on intestacy and therefore be able to stand to gain. In terms of preventing these claims, the circumstances of the claims usually arrive in the context of an elderly and vulnerable person being taken advantage of, particularly by family members. So it isn't always possible to stop these claims or from people acting in such an underhanded way. But sometimes it's actually the lawyer who can be that last line of defence. A competent lawyer would usually take instructions from the will maker alone, without family members present in the room, and ask a series of questions and probe and test the instructions that are provided by the will maker to satisfy themselves that the will maker has testamentary capacity. They might also request that the will maker provide some sort of medical evidence just to make sure that there's a contemporaneous note on the file recording the capacity. That way, if there is a disgruntled family member who comes along down the track to try and make these kinds of allegations, there's some really strong evidence there to back up the will. In terms of what a will maker can do to prevent their estate from dealing with these matters, sometimes it's really difficult and they can't really help it from transpiring because they're very reliant on someone to help them, and they're just quite fragile and not in a state to really object to the process goes underway. But it is really important that estate planning is resolved early on when somebody has capacity and they're fit and able, and not leave it on that ever-growing to-do list. A history of wills when the will maker clearly had capacity can always be utilised as evidence as well in the event that a final will is disputed. Additionally, if the will maker instructs their long-standing lawyer who has prepared various wills in the past, then if they do come to that lawyer when they lack capacity or somebody's influencing them to change their will, hopefully the lawyer will know that something's up and put a stop to it. There are, however, many cases where no one really finds out about this final will that was made in suspicious circumstances until after the will makers pass away. And that's when it really turns into the litigious matter. Our role then would be to try and usually prepare a very detailed timeline of the lead up to the making of the will. That would include what was happening in the deceased life, what were their medical issues, what were the family dynamics that were going on, and we try to reconstruct that puzzle. So the key message, I think, is that if estate planning is looked at early on, and if it's done correctly with the lawyer recording really good file notes and having supporting medical evidence in the event that the client is elderly and they think that capacity could be in question, that way it can be used by the deceased person's estate to prevent a claim from a disgruntled beneficiary who might try and bring about one of these claims. The second claim I'll be talking about relates to informal wills. These are wills that don't entirely comply with the necessary formalities of making a will. And every state has legislation that deals with the formalities, but generally speaking, in order for a will to be valid, it has to be in writing, signed by the will maker with the intention of executing a will, signed in the presence of 2 or more witnesses, and the witnesses must attest and sign in the presence of the will maker. And informal wills often arise in the context of a do-it-yourself will kit or a homemade will, and might not be witnessed by 2 of the witnesses, or might only be witnessed or might just be signed by the will maker or not even signed at all. For the court to be able to consider whether or not an informal will should actually be admitted into probate and therefore the estate being administered on that will, an applicant would need to demonstrate that there is a document. The document demonstrates the deceased's testamentary intentions and that the document contains dispositive intentions, which are that the document was intended by the deceased to actually be their final will. Usually that third step is the biggest hurdle because there's often a validly made previous will, and also because homemade wills don't contain a usual clause that most wills have, which state that the previous wills have been revoked. So breaking down each of those elements, I'll start with a document first. So that could be anything such as writing, drawings, photos, soundtracks, films and videos, and anything that's effectively capable of carrying a definitive meaning. There was a case in 2017 in Queensland where an unsent text message in the draft box of the person's phone, where he actually labelled it as my will, was actually admitted into court as an informal will. We've had a matter recently which we were able to settle without it going before a judge and get it through the probate registry, where the deceased actually hand wrote her own will, and she went and got her neighbour to act as a witness, but she didn't get that second witness, and then she took her own life a couple of days later. And in order to get that will admitted into probate, we had to go through a number of steps, and we had to obtain affidavits from the police who found the will in her house and also from that witness. And the third affidavit we needed was from a doctor confirming that she had testamentary capacity. And that proved to be the most difficult step, because the doctors were all quite reluctant to provide any information, especially on oath, because they were aware of the circumstances of her death, and she had just gone to see the doctors a few days before her death. So it took quite a lot of persuasion and follow-ups to get somebody to swear an affidavit and essentially get that will admitted into probate. So all in all, it really just delayed the proceeding, granting of probate, I should say, by close to a year, which had flow-on effects of not being able to sell the property, mortgage payments outstanding and debts, and it became quite complicated. And in that particular matter, it was really important to try to get that will admitted into probate, because the deceased left her estate in her will to her 9 siblings. And if we couldn't prove that will, she didn't have any other wills, and she would have died intestate, meaning that her estate would have actually ended up with her parents because she didn't have a spouse and she didn't have children. So the outcome could have been completely different in terms of who was to inherit from her estate. The second element that the court would look at is testamentary intention. So it needs to be a document that records the intention of disposing assets after death, and not a document that talks about gifting someone a gift or money during the will maker's lifetime. And the third most difficult element, which is the dispositive intention, meaning that one would have to prove that that particular document was meant to be the final document. It's not, it wasn't intended for it to be some notes that the will maker planned on taking to their lawyer or a trial run. It was actually, that was the final version of the document. There were some cases in 2019 which dealt with informal wills. In the following case in Reed Webster, the court held that an informal document was a will because the deceased had, she signed it, and she only signed it in the presence of one witness. She told a friend following her divorce that she wanted to make sure that her husband didn't receive any of her property or the farm, and she wrote the distributions of her estate on a piece of paper and had the friend sign it as well. In the matter of Reed Prian, the court held against an informal will, where the informal will was actually a file note of a solicitor who took instructions from the deceased about their will. The deceased signed the file notes, but they died before the deceased before the lawyer had an opportunity to actually draft the will and for the will to be signed. The file note had the letter Q throughout the notes, and the court had to question the lawyer about what that meant. And the court felt that because there were so many questions about some of the instructions in that note, that the document itself was not intended to be the final will. In summary, what the court will look at in order to make an informal will are the following types of elements. So if the informal document is titled Final Will and Testament, that's a tick in favour. If it says, if the deceased was unfamiliar with the relevant formalities, so if this was the first will they've ever prepared and they're not familiar with how a will is usually prepared, then the court might be more mindful of considering it to be an informal will. And if there is any evidence that showed that the deceased stored the document in a very safe place, that would show as well that that to them was their final will. Some of the factors against an informal will include if the deceased had a history of making wills with a lawyer, and so it was evident that they were aware of what those formalities would be, but then they failed to do so. And also if the document has limited content that requires explanation as to its meaning. So in summary, you can see that the court will take a strict approach to the formalities of a will. And even if someone is successful in being able to argue that an informal document can be admitted into probate as an informal will, it's a very costly timing and draining exercise for the family and the person who's trying to propound that will. So again, it really comes back to getting those documents in place and doing it properly with an experienced lawyer who can make sure that it satisfies all of those formalities. And now onto my third topic, which is abuse of enduring powers of attorney, or also elder abuse. And elder abuse is something that can also take the form of financial abuse while the will maker is alive. So just like in the example of a will maker being influenced by family to make a will, they could also be influenced to make a power of attorney or remove a previous attorney and appoint the family member who is taking advantage of them. It's not uncommon for us to see financial attorneys using that person's money as if it was their own, and they've played a part in having a will drafted which benefits them. They'll spend the person's money on themselves, treating the funds like an early inheritance. So the example I mentioned earlier on in my presentation, where the deceased had made 3 wills in close succession, he also at the same time appointed that executor to be his financial attorney, and the financial attorney went to town thinking that he was essentially going to inherit that money down the track and was spending that money on himself, including renovating his house and giving himself carer fees and paying for flights and accommodation. So if you suspect that this is occurring to someone you know, there's a few steps that you might be able to take. The first is finding out if someone is actually managing that person's affairs and seeing the documents in place. Asking that person if they might be prepared to share the financial information so you can check that everything's above board. And if the matter can't be resolved amongst the family or those close to the person and legal assistance is required, then there's a number of steps that we can take to try and resolve the matter. And this could include applying to the relevant tribunal in Victoria VCAT and in New South Wales NCAT for orders seeking copies of the accounts of the principal. Applying to the tribunal for the attorney to be removed if it's clear that the attorney has been breaching their duties to act in the best interests of the principal. In Victoria, you can request that VCAT commence what's called an investigation by the Office of the Public Advocate, where they'll appoint an investigator to look at these issues in more detail, sit down with close contacts of the principal and work out what's going on. In Victoria, if misappropriation is detected, then one can seek orders for compensation during the person's lifetime and also within 6 months of the date of death. In New South Wales, a similar application can be brought, but it's in the Supreme Court. So just like with a will, how can this you prevent this from happening to you? Well, good planning really assists and getting it done early on when you have capacity. The other thing is many people think that young people don't need powers of attorney, but young people often stand higher chances of being involved in situations which might lead to incapacity. For example, travelling, driving, adventure activities. So they are in a way more at risk. It's also really important to pick someone and try to pick the right person who you rely on, because if you don't pick anybody, it leaves the door open for someone to make an application to VCAT to appoint an interested person, such as a parent or a child. And you might not want that person to hold such a position because you don't trust them or you don't think that they're suitable for that role. So to conclude, it's clear that without really good advice and properly drafted documents, one's estate can be exposed to litigation. This too can apply while someone is alive if they don't have powers of attorney in place or the right people are not appointed. You can leave yourself open to being taken advantage of. Unfortunately, sometimes there is nothing that can be done until after the event has actually occurred. However, forward planning can really minimise the risk to avoid disputes from occurring. Thank you.
Thanks, Ilana. Just got a couple of questions. Do you believe that COVID has impacted these claims, and if so, how?
Yes, we do. I think due to the lockdowns, there were a lot of people stuck at home and thinking about their mortality, and they might have not been able to schedule a meeting with a lawyer or actually meet with anybody because of the gathering restrictions to sign their documents. So we'll probably see in time, I think over the next couple of years, a lot of informal wills surfacing. And in fact, I had one early on in the lockdown when a client was stuck in hospital and the hospitals weren't letting anyone in. And before anything could be done, she declined really badly and she passed away. So on the informal wills front, we'll probably see a lot of that in the future. In terms of the elder abuse aspect, there were a lot of people who were really isolated and they had limited people who were able to assist them. So I think we will also start seeing that in time and finding out about that kind of abuse.
Thanks. And do you believe these are problems only faced by elderly clients? And if not, how do you think it impacts younger clients?
Yeah, well, as I sort of mentioned, young clients as well can be at risk because things happen when you least expect them. I've had cases where people in their early 30s have died out of the blue. No one expected it. They didn't have any estate planning documents in place, and it really became a complicated mess for their families. So I think you're never really too young to have these documents in place and get your affairs sorted.
Great, thank you, Ilana. So we're moving over to our next speaker now, which is Walter MacCallum, who's a principal in our Sydney office. Walter has over 20 years of extensive dispute resolution experience. He advises and represents individuals, including executors and family members and disappointed beneficiaries, as well as family enterprises, corporations, and not-for-profits. Walter is acutely aware that the best outcome may not lie after a lengthy and expensive litigation. He's a tough negotiator, always looking out for his client's best interests, and I'd like to hand you over to him now.
Thank you very much, Claire, for that introduction. Hopefully I don't come across as too tough today. Some of you already know Ilana and I, but most of you don't know our new moderator, Claire Hesbrook. I hope I don't embarrass Claire here, but I'd like to introduce you to Claire. She's our new special counsel, soon to be principal in the estate planning team here in Sydney. Claire has a wealth of experience, having practiced exclusively in estate planning, both here and in England. After commencing her career in London and Bristol as a wills and estate lawyer, she came out to Australia to work at PwC in their private client services division. She then worked for McPherson & Kelly here in Sydney for 6 years before coming to Russell Kennedy. Claire focuses on the front end stuff, wills and estate planning that is, although she has been known to pull on the gloves when disputes arise. She's got an enormous amount of experience in will and estate planning in Australia, and also involving foreign jurisdictions and foreign assets, not just in Europe and England, but also in Southeast Asia and America. We're extremely excited to have Claire at Russell Kennedy. So the area I wanted to talk about today is in the area of claims against estates, not in challenging wills as Ilana has discussed, but in actually making claims against the estate. There's often a crossover between these two types of claims, where claimants will often make a claim challenging the validity of the will, but also in the alternative making a claim for provision from the estate itself. In every state and territory of this country, there are similar but differing pieces of legislation that enable certain defined classes of people to make claims on testators' estates. These claims are commonly called, as Ilana said, family provision claims, and they're not to be confused with claims made in the family court, although the outcome of property settlements in the family court can often have a bearing on family provision claims made later. A little bit of history first, and it's important to get this grounding to understand how this legislation works. The legislation started about 100 years or so ago here in New South Wales, and grew out of what was perceived to be at the time a need to uphold certain community standards. It was largely in response to two well-publicised circumstances where prominent Sydney identities had left the majority of their estates, one to his second wife of a few years and one to his mistress of ill repute, leaving the first wives and the children of their first marriage without any adequate provision. So the earliest form of legislation that came into New South Wales was then followed in the other states later on, but initially those claims were limited to spouses, and then subsequently to that, children were included. And then over the next 100 years, there was a growth of categories of classes of eligible people who could make claims. You'll see there from the first slide that I've got up there, there is a very large gamut of and wide range of types of eligible people that are capable of making claims if they fit through the proper hurdles. Historically, the most important thing I want everyone to understand here is that family provision revolves around the moral obligations of the will maker, and that is often set in stark contrast against the principle of testamentary freedom, which is essentially the right of every person to make their own will. So looking at that schedule there, who can make a claim? So the first hurdle, and I'll try and step through this piece of legislation because it is able to be stepped through, although it does mesh together once you run these types of cases. As you'll see from the slide, there are a large number there. I haven't got time to address all of them today, so I'm just going to spend a few minutes talking about some of those categories, mainly to raise awareness about these categories, that they do exist, and hopefully provide some pointers for those will makers and their advisors listening in today. The first category I wanted to talk about are de facto partners. Quite rightly, de facto partners are in the same category as spouses by marriage. However, the relevant family provision acts in each state and territory do not have their own definitions of what de facto relationship is, and they prefer to adopt the applicable state-based legislation dealing with de facto relationships. So, for example, in the New South Wales Succession Act, it adopts the definition of de facto relationship set out in the Acts Interpretation Act, and the Victorian Administration Probate Act, dealing with family provision claims, adopts the definition provided in the Relationship Act. Again, to complicate things again, each of those state-based pieces of legislation have variations on the theme of what a de facto relationship is. The point I need to make here is that care needs to be taken when assessing the applicable law and whether or not you or your client is in a de facto relationship. Importantly, and in all jurisdictions, the test here in family division claims as to whether or not someone is in a de facto relationship is what the relationship is determined to be as at the date of death. And this can be often harder than one would expect. I've got a current case at the moment where the relationship is under challenge as to whether or not a de facto relationship was formed by the date of death. The circumstances that I won't go into now led one to believe that it got down to the fact that actually had the deceased died almost a day later, the claim would have been extremely different. But as it stands now, there is a very grey area as to whether or not the actual relationship existed at the date of death. The next category I wanted to deal with briefly is children. Obviously, children by lineage and by blood are included automatically as eligible people, and that includes children born from the deceased within a marriage or de facto relationship. It includes adopted children and ex-nuptial children as well. However, stepchildren are not automatically considered eligible persons in all legislation. For example, in New South Wales, a stepchild will only be considered an eligible person where the stepchild was dependent on the deceased and was a member of the deceased household at any time of the deceased house, falling what I call into the second category or the second group of eligible people under the New South Wales legislation. And I'll refer to that second group a little bit later and explain why they're treated differently in New South Wales. Next category is grandkids. What about grandkids? There's been a huge growth in this area and the interpretation of the case law around grandkids over the last 20 years or so. I think the factors having a bearing on the growth here is that we're seeing, obviously, over time, the growth of extended families through new cultures coming to Australia, where that family unit regularly includes grandparents. We're also seeing an increasing financial dependence on grandparents to assist their grandchildren with expenses, particularly things like school fees and setting up in life. And also, there's always the ever-increasing barriers to entry in the property market in most capital cities that we're experiencing today. All these factors, I think, have had an impact on this category, being one of the growth areas in this area of the law. Again, as expected, there are variations, unfortunately, across the states and territories with the various pieces of legislation, but the general theme in all jurisdictions when it comes to grandchildren is dependency. So if a grandchild can show dependency, even partial dependency, then the eligibility hurdle may be cleared. I don't wish to go today into providing a treatise on the meaning of dependency. However, a useful summary could be that, firstly, dependency is usually financial, but can be emotional as well. Secondly, mere emotional dependency will often not be enough, and the dependency must be direct, i.e., it can't be via assistance to others, such as parents. The last category I want to deal with today for the purpose of eligibility is carers. In New South Wales, carers are not specifically stated as eligible people, as they are in Victoria, which I'll get to in a second, but they can be found to be eligible people if they are dependent and a member of the deceased household. The classic example here is the live-in carer who over time bonds and forms a very strong relationship with the deceased. Another category of where a carer could fall into, again, along with that similar example I just gave, is the final category in the New South Wales legislation of eligible people, which is a person who at the time of the deceased death was in a close personal relationship. They're the key words there, close personal relationship. In Victoria, to be considered eligible, the carer needs to be registered as a registered caring partner within the meaning of the Relationships Act. Once registration is approved and the registration is valid at the date of death, that person immediately ticks the box to become an eligible person. So the next slide, if you can take me through to that, please, Claire, is limitation periods. I wanted to briefly talk about that because this is something that is on every lawyer's mind and should be on advisors' minds as well, is that the various different pieces of legislation have different limitation periods, or should I say time limits within which someone has to bring a claim on the estate. It's very important to be aware of these if you're advising your client or acting as an executor. Most jurisdictions these days apply these limitation periods or deadlines for commencement of claims very strictly, and if a claim is filed out of time, only in exceptional circumstances will the claimant be able to get what is called an extension of time, and they'll not only have very good reasons for explaining to the court why they failed to file in time, but also arguably a prima facie case on the merits. The important thing to note from a strategic and a procedural point of view is that these types of limitation extension applications are not normally heard at the beginning of the case, but are heard at the same time of the trial. This creates a difficulty on most of the time both sides of the equation, because both the plaintiff and the defendant will need to prepare and run for a trial, not knowing whether or not the limitation period will be extended, which is normally heard at the beginning of the trial. While I'm on procedural points, there are two other procedural points I want to make clear or explain to everyone today, because they have a bearing on the types of family provision claims that we're seeing being made, and what I attribute to largely an increasing growth of claims as we move forward in our modern society. The first point I want to make procedurally is that most, if not all, jurisdictions have a mandatory or a strongly encouraged regime of mediation that is imposed upon the parties well before the trial. This is intended with good intent, obviously, as a cost-saving exercise, and also in recognition that such claims are emotionally charged and therefore often benefit from mediation. I should say that in my experience, around 70% of family division cases settle either soon after the mediation or at the mediation itself. The other reason I would suggest as to why mediation is often successful is that these types of cases involving lengthy affidavits of disclosure of the relationship between the deceased and various members of the party, of the family, can often be an airing of the dirty washing of a family's history, which a lot of people want to avoid getting into court at an ultimate trial. The second procedural issue that has a bearing on these types of claims, I believe today, is the cost of the proceedings. Usually the usual order, and there are exceptions depending on the size of the estate or the conduct of the parties, but usually, all things being good, the cost of the proceedings, and that is both sides of the claim, plaintiff and defendant, are usually paid out of the estate. The consequence of these two factors, and it's often accompanied, unfortunately, by healthy doses of greed, financial need and emotion, I think has resulted in a steady increase in claims. One of the barristers we regularly brief up here has often said to me, as a cynical note, that this area of the law is one where, unlike most areas of the law, the insolent, the indulgent, the indolent and the incompetent are often rewarded. Next slide, thank you please, Claire. So once you have reached the hurdle of eligibility, which is the first gateway into making such a claim, for the court to make an order for provision, you have to convince the court, in considering all the circumstances of the case, firstly that the court is satisfied that the claimant has not received adequate provision for his or her maintenance, education and advancement, or maintenance and support, depending on which state you're in. And the second limit of that is that once that has been established, the court then needs to determine what provision should be made. Now, although it's described in Singer and Berghaus, which is the leading High Court case setting this out, this two-step process is often heard and determined at the same time because the factual matrix is heavily interlocking. So the first involves a consideration essentially of the moral claim that the claimant has on the state, and the second involves a calculation of what that adequate provision should be made. Importantly, from a timing point of view, again, it's important to note that the determination of these questions takes place at the date of the trial. And what may have been more than adequate provision when a will is made in 1970 may not be adequate provision today. In New South Wales, in particular, I talked before about this second group of categories. There's 6 categories of eligible people in the New South Wales legislation, and the second group I call them, they have an additional hurdle they need to show before we get to that two-step process, and that is they need to be able to prove to the court that there are factors warranting for them to be considered eligible and thereafter able to go through the two-step process. You'll see from the slide there, I've set out what those 3 categories are of the factors warranting, and that is the former spouse, person who was at any time dependent and the grandchild, and also the person in the close personal relationship. That quote there at the bottom, which essentially is a very good definition of what factors warranting means, is it quite simply, if you are able to show that the status of the person claiming eligibility is such that that person would have been regarded as a natural object of intimacy recognition by the deceased, you'll be able to reach that hurdle and then go forward with the next stage, which is the assessment. So then at that next stage of the assessment, when determining whether or not provision has been adequate, and if not, what provision should be made, the courts are able to look at a very wide range of factors. And the various pieces of legislation, again, are broad in listing the types of things or factors the court will consider. Dealing with the New South Wales legislation as a guide, Section 60 of the Succession Act sets out a huge number, and I'll just briefly list them. The first one is the nature and duration of the relationship between the claimant and the deceased. The next one is the nature and extent of any obligations or responsibilities owed by the deceased to the claimant. Next is size, nature, extent of the estate, whether or not there's notional estate, and I'll come to that later. Next, the present and future financial needs of the claimant or claimants, because there may be multiple, and also that of the beneficiaries. Where the claimant is cohabiting, the financial circumstances of that person also come into play. Things such as age, disability and medical conditions are also considered. Likewise is the claimant's contribution to the deceased estate during the deceased lifetime, any provisions made prior to death, and also things such as statements made by the deceased prior to death as a testamentary intention. Lastly, there's also an element of character and conduct of the claimant before and after the death of the deceased. And then the final category, which covers everything that hasn't already been covered, is any other matter the court considers relevant, either at the time of death or at the time when the claim is heard. Pertinently there, the court can take into consideration post-death conduct by the claimant. So you can see how broad all these factors are. I don't propose to go into each of those factors today, given the time we've got, but very, very quickly I want to deal with estrangement. Estrangement is not just the breakdown of relationship between de factos or spouses, but also relates to estrangement between the claimant and the deceased. The effect of a finding that the parties were estranged could have the effect on either no provision being made, any provision being reduced, or no effect on the claim for provision at all. It is really a question of the degree, and most of the jurisdictions look at that in terms of extent. The second factor that's often been raised that goes up with those factors is whether or not there's disentitling conduct. Now, in New South Wales, Victoria and ACT, disentitling conduct is not a bar to a successful claim. It just has an effect on the claim or the extent of the provision that the court may make. Next slide, please, quickly. I'm moving quite quickly now, I'm afraid, given the time. But I just want to deal quickly with notional estate because this is relevant to New South Wales viewers. This is the only state in Australia that has a piece of legislation, and it's a Curley addition. Basically, what it says in simple terms is that if after having found that a claimant has not been adequately provided for, and in weighing up all the financial needs and wants of the claimants and the beneficiaries, the court may make an order for certain assets that were outside the estate to be deemed notional estate and thereby the subject of an order for provision. So in order to pull back these assets outside the estate to bring it in, there needs to be what's called a relevant property transaction. And in simple terms, a relevant property transaction is an act or an omission which results in property being held by another party or subject to a trust, and where full valuable consideration is not given for it. So you'll see I put up on the slide there that there are time periods for these types of relevant property transactions to have occurred in order to be caught by a potential notional estate. Now, the court is not necessarily going to look to notional estate unless in weighing up all the options there is insufficient assets to essentially to go round. But what it does look at is, as you'll see in those 3 categories, 2 of the 3 categories, the last 2, don't require intention, where the 3-year category does require proof that the testator intended to devolve himself of an asset or property to avoid that going into his estate. Classic and common examples of where transactions can be effectively undone, or the assets supporting those transactions are dragged back into a state. Firstly, an omission or failure to sever a joint tenancy before death, with the result that the deceased's interest in the real property automatically passes to the surviving tenant. A second one is a nomination to the super fund trustee in a self-managed super or managed fund, where the nomination is given to pay the deceased death benefit to a person or persons other than the estate. Things that seem quite normal. Those types of transactions can be undone and deemed to be notional estate. So wrapping up and looking at what we can do about this, what about this piece of legislation, if we could go to the next slide, please, is that first and foremost, prevention is better than the cure, because these types of cases have been known and will no doubt continue to destroy families. The amount of evidence that is put on and the dirty washing, to coin that phrase again, that gets aired, is often so destructive that families never recover from these types of cases. So, as I say, prevention is better than the cure. But unfortunately, I haven't got great news for our viewers, because primarily family provision claims cannot be contracted out of. So all you can really do is bring in minimisation strategies in order to minimise the risk of claims. Now, first and foremost, the most important thing to do is to be aware of this legislation and consider it. And if a will maker or an advisor advising a will maker is looking at making provision for certain beneficiaries or certain people of natural testamentary object, then they need to be very, very careful about how and why they're doing it. Things like who is to receive equal amounts, who is to receive unequal amounts, and why, what type of assets to be given outright through a trust, and what risks are there of claims being made by potentially disgruntled family members or dependents or other eligible people falling within those very broad categories. Communication is often very important, and again, unfortunately, it can be a double-edged sword, but depending upon the circumstances, communication with your family members is very key to get them on board, to understand what the estate planning is, and that hopefully we have seen, not always, but we have seen that it will minimise the risk of claims being made post-death. Another aspect that I mentioned before, which is one of the factors taken into account in Section 60 and other equivalent pieces of legislation, is a statement made by the will maker. This is normally a statement or a memo of wishes that is confidential and held with a will, and it's often used to explain why a child, for example, has received nothing because they've received an asset or in their lifetime, or they're no good, or they have been guilty of disentitling conduct. Those sorts of reasons need to be put in full and frank disclosure and supported by evidence where possible, and then they are kept with the will, and hopefully they never see the light of day unless and until such time as claim is made. But if they are, then they can be used to the testator's advantage. However, also a caution in using these is that often these types of statements have been used against the deceased estate, as it were, to highlight the fairness or the failure to abide by the moral duty that a testator has to the natural testamentary objects. So again, it's a double-edged sword and has to be tailored and thought about on each occasion, depending upon the complexities of the family unit. Deeds of family arrangement have often been deployed successfully as well. Again, they're not foolproof, but they deal with and create binding relations inter party between the surviving family members. They're often used in family businesses or large estates with complex assets, often been used successfully in the past. In New South Wales, there's a limit available to procure a release from a potential claim, but the real trigger and the real flaw in this is that the court has to approve the release. The New South Wales court does so very, very reluctantly, and it will involve a full assessment by affidavit evidence of all the financial means, needs and positions of the various parties. Again, it's a disclosure that the parties may not want to have and then be faced with the court's reluctance. Where we have seen it successfully deployed and approval given is at the end of family law property settlements, where as a part of the family law property settlement, the parties agree to go and approach the court to get this Section 95 release. In the end, lastly, however, there's no surefire way to avoid a possibility of a claim other than really giving it all away before you die. Now, that may sound trite, but I've actually seen it happen, and some clients actually do that. Thank you very much, Claire, and everyone else for listening. I hope it wasn't at too much of a breakbeat speed, but I had to get that through, but thank you very much.
Thanks, Walter. So we've had some questions come in. We've got a little bit of time left if we can go through some of those now. So we have a question from Lily who said, to what extent are the notional estate rules inhibiting certainty of estate planning in New South Wales? So I might direct that to you, Walter.
Well, ever since notional estate has been brought in, it's always created uncertainty. That is to say, from a practical point of view, it's normally the advice tailored on each individual circumstance that notional estate has to be there, has to be considered. But as I mentioned before, courts are normally reluctant to disturb what is done outside the estate and drag things into notional estate unless and until they feel that there are insufficient assets to make adequate provision for the claimants and the beneficiaries within the estate assets. So there's that first hurdle that you have to find as to whether or not that can be done. Now, the joint tenancy one is a classic one, and I would always assess it and advise clients that if there is a risk of a claim being made, then parties should consider severing the joint tenancy, which is an easy thing to do between husband and wife, not so easy to do between other co-owners, but husband and wife is a stamp duty exemption on doing that. So it's a one flick of the pen on one piece of paper to do that. But you cannot avoid it as an uncertainty, and it is always there, unfortunately.
Thank you. We've had another question come in from Jacqueline asking about love interests and how can we protect the estate of a deceased after he's passed away from somebody who's claiming to be a de facto?
The short answer again is that you can't. I was in a case last year, a very, very large estate where out of the blue, a same-sex lover claim, so to speak, was made. It was from the gift, for example. The family division claim case law is full of a plethora of instances like that. And as I mentioned before, one of the factors that the court looks at is whether or not there have been any prior transfers of assets or properties to claimants or beneficiaries during the testator's lifetime. So they are taken into account. Often you see fights where one sibling will say, my brother got a house back 5 years ago, I now should get the lion's share of the estate, it's not fair. You then end up in a calculation argument as to what was the real value of that house back then, what would it be valued at now. You end up in very complicated calculation arguments. What's the benefit of what he did with that property? Often, particularly in a rising property market, we see investment properties being given back in the 60s and 70s and 80s going through the roof now, and that beneficiary may have received a huge amount of benefit where the other one hasn't. So that leg up type thing is often a contested area, and it's a difficult and vexing one. Most importantly, I would say, is that always document these types of things as well.
Great, thank you. So we're pretty much out of time now. We've got a few questions still coming in which we will seek to respond to after the webinar. Some of them are a little more complex, so we need a bit more information, but I just wanted to thank our presenters firstly, and also everybody who's joined us today. Thank you for joining. There will be a survey sent to you after this. We'd be very grateful for your feedback. You can also use the QR code which is on the screen now. Always very happy to assist you with any of these types of issues for your clients. And just to remind you that Russell Kennedy is here to support you through the COVID-19 situation, and please don't hesitate to get in touch with us. Thank you.
Thank you, Claire.
Thanks.
Thank you, everyone.